Well, welcome back to my lovely apartment here in Brussels, and I'm happy to be with you again on another topic that might have quite a practical value for some of you, which is determining in practice how to apply the GDPR and how to apply or to say when to apply the Law Enforcement Directive and when to apply the GDPR. And some basic things about the scope I already said before. So now we will go into more detail about this, and you will see that it's quite a controversial topic because obviously this delineation between the GDPR and the Law Enforcement Directive is supposed to be seamless. If you apply the GDPR in an overly broad manner, you basically sort of infringe the scope of the directive, and vice versa. If you apply the directive in an overly broad manner, then you are affecting negatively the scope of the GDPR and entering its territory. So let's move on to the slides. Yeah, again, the titles that I had disappeared like in my first presentation, and I don't know why, and I apologize for that. So as a reminder about the scope, this is the main provision basically that speaks about the scope. Article 1, paragraph 1 of the directive, which says a lot of things and not much at the same time. So it says again that in order to apply the directive, both material and the personal scope have to be met. Material scope is defined by the purposes of the processing. So why are we processing personal data? So we can meet the material scope of the directive only if we if we process personal data for the purposes of prevention, investigation, detection, or prosecution of criminal offenses, or the execution of criminal penalties, including safeguarding against and the prevention of threats to public security. Quite a long provision, which can mean a lot of things, and that's what we're going to try to discuss in my presentation. Just to try to sort of dismantle it in the beginning immediately, when it comes to several elements that are here, initially I would like to say that prevention of criminal offenses is a term that could be considered in quite a broad manner. So there, the material scope is harder to define than when we speak about investigation, detection, or prosecution of criminal offenses. There we are much more clear about what are we actually doing and why are we processing personal data. Then we have another second area, which is the execution of criminal penalties. And that is something also quite easy to define in the sense that yeah, we are, someone got a prison sentence, so now we have to enforce this prison sentence, for example. So that is also the third element of the material scope, which is easier to define. And then we have this including safeguarding against and the prevention of threats to public security. Including is basically telling us that this is something that is part of all these purposes that we mentioned before. Prevention, investigation, detection, or prosecution of criminal offenses or the execution of criminal penalties. So it belongs there, but it also somehow opens up other areas of law enforcement activities, safeguarding against threats to public security, prevention of threats to public security. Again, something that can be very broadly defined, and the question is here, how are those processing activities then linked with the other purposes that we mentioned before, and what does this including mean actually? And then we come to the second element, which is the personal scope, which says processing needs to be done by competent authorities. And as we mentioned before, competent authorities, which are defined in Article 3, Paragraph 7 of the directive, can be public authorities that are competent for these purposes listed above. And there we are quite clear about who are we talking about. It's police, prosecutors, criminal courts, prisons. And then we have this other part, which of the definition in litera B of Article 3, Paragraph 7, which speaks about other bodies or entities entrusted by national law to exercise both public authority and public powers for the purposes mentioned above in the material scope. And there it gets a bit more tricky, and this is a question that I got from Ramin in the first presentation that I forgot to reply. It's a good opportunity to go back to that question. You were asking me about what does it mean, this litera B here? What are those other bodies or entities entrusted by national law to exercise public authority and public powers? Especially, what about those private bodies that could be included in the definition of competent authorities here? And here, well, we can, I think in discussions before, you already sort of understood what this is about. It was about, first of all, making the Law Enforcement Directive future-proof in case there are some European member states, EU member states that would like to or are already doing that, outsource some of the typically coercive powers of national authorities, or would like to outsource some law enforcement tasks to private entities so that they could be also covered by the definition of the competent authority. It is quite restrictive because you have to be entrusted by both public authority and public powers. So it really is about, in the end, private prisons or private policing. And I don't think this, to be actually perfectly honest, I don't think this idea of covering any sort of private entities would be included in the directive. And I think the directive in its personal scope would be limited only to public authorities and would not even think about this future proving if it wasn't for the United Kingdom, who was insisting on having this possibility, and they managed to negotiate well and get it in the directive, and then they decided to leave the EU. So basically it's a heritage that will remind us of those good times that we had from 1973 until now, I think. I'm sorry about again, I have to apologize for the slides that are way too scarce, and I don't understand where parts of them disappear. But okay, let's try to work with what we can. What this slide is about what is in detail a definition of a competent authority. So we have two elements, as I said. We have a public authority which is competent for the purposes of prevention, investigation, detection, prosecution, etc. Nothing more to add on this. That's pretty clear. And other body or entity in letter B, entrusted by member state law to exercise both public authority and public powers for those purposes. So under letter A, we have formal organs of the state covered, while under letter B, we have a very restrictive notion because, again, I have to say we have to have both public authority and public powers vested by or entrusted by member state law to this body or entity. We have a lot of case law from the Court of Justice and the EU of what is public authority, what is public powers. So, and if we put it together, this end is quite important there. We see that the delegation of duties in the public interest does not suffice. So this is, again, a restrictive notion of what other body or entity might be considered as a competent authority. Meaning that, there are a number of companies that have, that were delegated with some duties in the public interest. And they might be privately owned or publicly owned, depending on the member state, but they do have some duties that the state delegated to them in the public interest. It could be telecom operators, it could be, I don't know, water company, electricity company, gas company. All these are delegation. All these are duties that those companies could exercise in the public interest, and they might receive this delegation from the state. But that is not enough to be considered as a competent authority under the directive, because you have to be entrusted by member state law to exercise both public authority and public powers. Those are then basically limited to examples that I gave you, like private prisons or private police forces, while, for example, a private forensic lab that might actually participate in some criminal investigation by carrying out certain analysis for the police forces or for the prosecutor would not be a competent authority, because the member state law does not entrust such a private forensic lab, privately owned, with both public authority and public powers. So that's about the definition of competent authority. I see a question from Mary Henderson saying that whether a private agency receiving a child protection concern would not fall under that description. Yes, definitely not. Not a competent authority under the directive. It doesn't have public authority and public powers. Moving on to the other element of the scope, which is the material scope. So that was for the personal scope, but the material scope probably even more difficult to define, and also decisive for defining the personal scope in the end, because remember, we have to be competent authorities for the purposes of prevention, investigation, prosecution, and detection of criminal offenses. And that notion, prevention, investigation, prosecution, detection of criminal offenses, execution of criminal penalties, including prevention of threats and safeguarding against threats to public security, that notion is the material scope of the directive, and whether you are a competent authority for those purposes or not will also be influenced by how you define the material scope. So you could even argue that for defining the scope of the directive, material scope is more important and more controversial than the personal scope. Now here on this slide, I would like to basically provide you with two different explanation of how this competent authority then is defined. So there are two different explanations of or two different interpretations, let's say, of what could be a competent authority. One is the explanation that would be provided or advanced by the European Commission, probably by most, if not all, member states. And another one is an explanation that I have personally for you. So I will provide you the reasons for both, and you can see what makes more sense. The European Commission and the member states argue that a competent authority is any public or, in very limited cases, private authority that even sporadically or in isolated cases acts in order to prosecute, prevent, investigate, detect criminal offenses, and blah, 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 the entire big sausage from Article 1, Paragraph 1. So they're basically saying in simpler terms that if you are an authority that normally applies GDPR, but occasionally, even if it's sporadically or in isolated cases, you have to do something which corresponds to the material scope of the directive. So prosecuting, preventing, investigating, and detecting criminal offenses, you become in that moment a competent authority under the directive, and you are allowed to process personal data under the directive. The most anecdotal examples I could remember and find is, these are real examples from one member state. I won't mention which one. For example, a fishing inspectorate that is prosecuting a fine for illegal fishing. So fishing inspectorate is a typical administrative authority that normally applies the GDPR. In that particular member state, illegal fishing is considered to be a criminal offense. So it's not decriminalized. It's not a minor offense or administrative offense like it would be in, I would say, majority of the member states. In that particular member state, this is a criminal offense. So basically, the argument is that this fishing inspectorate, which normally processes personal data under the GDPR, when they decide to prosecute a fine for illegal fishing, they become a competent authority under the directive, and for the purposes of prosecuting this fine, they are actually processing personal data under the Law Enforcement Directive. Another very similar anecdotal example is a fire brigade. In case a building does not have a smoke detector, not having a smoke detector, again, in that member state is a criminal offense. A fire brigade, which normally applies GDPR in its daily work, suddenly, in order to prosecute a fine for the lack of the smoke detector, becomes a competent authority under the directive and is allowed to, for that particular purpose, even if it's sporadically or in isolated case, process personal data under the directive. So that is how basically a material scope, or what is a criminal offense under your national law, in a way defines indirectly what is a competent authority, or indirectly defines the personal scope of the directive. Me personally, I have a problem with this because, first of all, why would we have two components of the scope if the personal scope and the material scope, if the personal scope is actually defined by the material scope? So that is already putting things sort of out of balance and making it less clear. And another reason, which is more important for me, is that I think that the directive was envisaged as a piece of legislation, a legislative act for processing of personal data for prosecution, prevention, investigation, and prevention of criminal offenses for traditional law enforcement authorities that have as their core task law enforcement activities. So basically, for me, a competent authority is only a competent authority that has statutorily as its main task the prevention, prosecution, investigation, detection of criminal offenses, execution of criminal penalties, and including safeguarding against blah, blah. To put it in even simpler terms, for me, a competent authority is police, prosecutor, criminal court, prison, and I have a lot of problems with, accepting or adding another type of authority to a definition of the competent authority under the directive. While if you follow the interpretation that is dominant, that is advanced by the member states and the European Commission, a lot of different authorities will be able to claim that they are a competent authority under the directive and apply, even sporadically or in isolated cases, the directive. That creates a number of difficulties, first of all, because then these authorities will have to apply to different legislations and might not know exactly when to apply what. So probably they will have a tendency to claim that whatever they do, they are actually a competent authority and apply the directive as much as they can instead of the GDPR. And another problem is that an overly broad interpretation of the directive actually then basically eats the space of the GDPR. And GDPR is a directly applicable piece of legislation. So it basically means that not only you are implementing incorrectly or applying incorrectly the directive, but you are also infringing in a way the GDPR. That's why I basically advocate for a narrow interpretation of the especially personal scope of the directive. Why am I saying this? Where am I basing my statement? Well, if you look at the intent of the legislator, which is a legitimate technique to interpret legislation, if you look at the Declaration 21 that was attached to the Lisbon Treaty, if you look at where the directive comes from, the fact that it comes as a heritage of the former third pillar, if you look at what the Directive 95/46 was covering before, and the idea that Directive 95/46 processing activities should be covered by the GDPR and not something else. And if you think about the fact that the directive or the LED should cover only those processing activities which were previously covered by the framework decision 2008/977, and you try to keep that border between those two instruments alive also under the new architecture, under new legislation, after the Lisbon Treaty, then you come to a conclusion that actually a competent authority can only be the one that statutorily as its main task has prevention, prosecution, investigation, and detection of criminal offenses. I see a question from Slovenia. I will come back to that question in the Q&A session. I know, because I'm Croatian, I know that you have a minor offenses system, and because we have it as well, as we basically, with some reforms, inherited from Yugoslav times. I think that's a big question also here, whether those minor offenses that in a number of countries are decriminalized and are treated as administrative offenses are in countries like Croatia and Slovenia part of the criminal law or not, and whether they should be covered by the GDPR or LED. Of course, you can say that under national law they are covered by, they are part of the criminal law in both Slovenia and Croatia. And that might be enough to meet the material scope of the directive, but again, for me, it's not enough. If you look at my sort of definition of the competent authority, it's not enough to basically meet the personal scope of the directive. Otherwise, we would have a number of competent authorities, both in Slovenia and Croatia, like, I don't know, city council that is imposing a fine for urinating on the street. So that is a minor offense that I think is normally enforced by the city communal services. So then they become, under this definition advanced by the predominant definition, they become competent authorities. So you have hundreds and hundreds of different competent authorities all over the place that sporadically in isolated cases can apply the Law Enforcement Directive. So we will get back to that later on, but that's just what I wanted to say for now. Now, coming more in detail to the material scope of the directive. We said that material scope means that you have to process personal data for the purposes of prevention, investigation, detection, and prosecution of criminal offenses. What is a criminal offense? That is a big question, because a criminal offense, as we've seen from the first part of my presentation, is very different notion in different member states. There are a number of member states that have clearly decriminalized a number of minor offenses and are being treated as administrative offense. For example, I accidentally drove through the pedestrianized area here in Brussels when it was introduced. So I didn't know that I'm not allowed to drive there, and I got a fine for that. And that fine was processed by Belgian authorities under the GDPR. because it is an administrative offense. It's clear that it's an administrative offense, no problem there. Then we have some other member states where all the offenses are somehow part of the criminal law realm or are criminal offenses. Either explicitly criminal offenses, like is the case in Denmark or Estonia, or minor offenses that are traditionally a branch of a criminal law, like in Slovenia and Croatia. And then we have other examples, like a very complicated example of Ordnungswidrigkeit in Germany. So criminal offense, as I said, can be a lot of things. What we have in the directive in order to help us interpret this is one provision, which is Recital 13, saying that criminal offense is an autonomous concept of EU law as interpreted by the Court of Justice of the European Union. So there we have a little bit of help, saying basically it's only a recital, but it still helps us because it says it's not what you consider under your national law to be a criminal offense that is decisive for this directive. It is actually an autonomous concept of EU law as interpreted by the Court of Justice of the European Union. So that now maybe is helping us to get out of the woods, but does it really? Because if you look at the Court of Justice of the European Union case law, for the moment we don't have case law that defines what is a criminal offense as an autonomous concept of EU law. When we find some cases about this issue, normally we have an envoi to the national law, basically saying that what a national law says is a criminal offense should be a criminal offense. Then we could try to borrow some other guidelines from the other European court, which is the European Court of Human Rights. European Court of Human Rights developed the so-called Engel criteria. It's a case, Engel versus Netherlands, an old case from 1976. Which says that when deciding whether an offense is criminal in the sense of Article 6 of the European Court of Human Rights Convention, of the European Convention of Human Rights, which is about the right to a fair trial, there are three criteria that apply. One is, how do you classify the offense in the law of the state? What is the nature of the offense? And what are the possible punishments? So we could try to then use the Engel criteria to say that this is what we will use, those three criteria, to define a criminal offense under the directive. And if you look at the minutes of the expert group meeting on the GDPR and the Law Enforcement Directive that are publicly available, this was an expert group between the Commission and Member States that was discussing how to transpose the directive. You could see that in their early meetings they were playing with this idea. They wanted to they were thinking like, yeah, maybe we should apply Engel criteria and then we will basically get out of the woods and understand better what is a criminal offense and better define material scope under the directive. But in the end, it was decided not to follow Engel criteria. You will see that in the later meetings, later minutes of that group from the later meetings. Because the Engel criteria were there developed by the court in order to provide certain protections or certain guarantees, procedural guarantees under Article 6 of the European Convention of Human Rights to individuals that were not useful, or that were not that we could not just take and copy in our system here, because here we are trying to define scope of the legislation and not trying to expand certain protections or certain guarantees that exist in the European Convention for criminal proceedings that do not exist in civil proceedings. So in the end, the Engel criteria was also discarded, and the only thing that was clear from all this discussion was that member states cannot qualify something as a criminal offense only in order to choose the applicable data protection law or the better suited or the less burdensome data protection law, which in this case is the Law Enforcement Directive. So the only thing that is clear from this process is that you cannot treat something under your national law as administrative offense but only for the data protection purposes say that it's actually a criminal offense. So you have to treat a certain offense as criminal offense for all in all other types of legislation that you might have, like the Criminal Code or Criminal Proceedings Act, Criminal Procedural Law, etc., in order to be claimed that under mild national law this is a criminal offense, and therefore the material scope of the directive is met. And this vagueness leaves us with a number of gray areas when we discuss about what is actually the material scope of the directive. I already mentioned the Ordnung Widrigkeiten in Germany, which are actually minor offenses, or you could even say they are administrative offenses, but eventually in the court proceedings that might follow after non-enforcement or non-compliance with the order issued on Ordnungswidrigkeit might end up before a criminal court. So in Germany, they decided to include Ordnungswidrigkeit under the national law transposing the Law Enforcement Directive. But from my perspective, EU law perspective, it's not clear whether this is fully in line with the scope of the directive. Then we have a number of other areas like border, asylum, and migration, which are traditionally areas that were that should not be treated in the same way as law enforcement processing, at least not under EU law, because it was clear that these areas were always governed not under the third pillar, but actually under the rules, at least when it comes to data protection, of Directive 9546 as transposed in the national law. But of course, it's very difficult to delineate border management and border control from preventing or investigating certain criminal offenses which might be linked with illegal border crossing or migrant smuggling and similar. And then we have another gray area which is interesting is this large-scale databases that we have on the EU level, which are actually set up either for migration or for law enforcement purposes, and sometimes it's very difficult to distinguish whether data in them, especially after they become interoperable, will be processed for migration purposes or for law enforcement purposes. Were they originally collected for migration purposes and then they were accessed by law enforcement authorities for their purposes, whether, how to clearly distinguish between data that in the interoperable solutions, how to clearly distinguish data that was obviously not collected for law enforcement purposes, like data from Eurodac or VIS, from the data that is law enforcement data that is in the Schengen Information System, for example. So a number of gray areas and a lot of uncertainty, I think, in defining when to apply what. And then we have another issue here that I wanted to mention, which is, again, I don't have the title, but what I wanted to mention here is whether it's something from a recital that is very important in order to explain us what does it mean to including safeguarding against and prevention of threats to public security. And this is Recital 12 of the directive. And basically, Recital 12 is quite detailed about why this, including prevention of threats and safeguarding against public threats to public security, was added to the scope of the directive. To put it in one sentence, it was included because the legislator, the co-legislators, wanted to make sure that police applies one law when they process personal data. So they wanted to make sure that police authorities do not have to juggle between GDPR and the Law Enforcement Directive unless it's obvious administrative processing like HR data. And therefore, Recital 12 and this inclusion in prevention of threats and safeguarding against threats to public security is primarily for police authorities, not for other competent authorities, even though I have to admit that the Recital 12 does mention other law enforcement authorities. And this prevention of threats and safeguarding against threats to public security is basically impersonating the preventive police function and includes the preventive police function within the scope of the directive. So we can say that this addition scope is defining better what does it mean prevention of criminal offenses, at least when it comes to the police work, because often police will do something without knowing whether this might lead to a criminal offense or not. Of course, the question is whether we should have been, as a legislator, so forward-looking and so open to police authorities and helpful, because I know that police authorities insisted this during the legislative negotiations, and that they like this addition in the definition of the scope. But on the other hand, I have to say that it's questionable whether this should have been done, because if you look at the police actions and police functions, normally when the focus of police action is in its preventive function, then the administrative law applies. So whatever police does in its preventive function might be later on scrutinized under the rules of administrative law. While when the focus of police action is in its repressive function, which is easier to define, investigating, detecting, and prosecuting criminal offenses, then normally the rules of criminal procedural law apply to scrutinizing the action of police. So if we have the distinction and this logic, administrative law on one hand and criminal procedural law on another hand, maybe we should have followed this logic with the data protection rules as well, and say that for preventive function of the police, the GDPR should apply, and for repressive function of the police, the Law Enforcement Directive should apply. That would make the scope even more narrow, but I think clearer defined. And of course, we can have a discussion of whether this should have been done or not. But I'm just saying that I think it's a valid question. In the end, as I said, it was decided to clearly to include a preventive function of the police in the material scope of the directive. Now, very briefly, in the time that I have, I want to give you a concrete example of difficulties that we have with delineating the scope between the directive and the GDPR, which is processing of personal data by financial intelligence units. So I'm hoping that there are some people, representatives of the FIUs here on the list of 44 we are right now, that could actually say maybe a few words about a comment about what I say. I don't have much time, so I will go quickly through this, but I will just tell you that the anti-money laundering legislation in the EU was initially adopted on a legal basis for internal market. That you have in the 4th Anti-Money Laundering Directive, that you have in the 5th Anti-Money Laundering Directive that is being transposed either last year or right now. So you will see in those pieces of legislation that they clearly say that for processing of financial intelligence units for the purposes of this European law on anti-money laundering, these two directives, the Directive 9546 applies, or afterwards GDPR applies. But we also have a very new directive from 2019 on laying down rules facilitating the use of financial and other information, where actually the legal basis was not internal market, it was police and judicial cooperation. So that's quite an interesting development in how the EU anti-money laundering legislation is being developed. So what do we have to do under the anti-money laundering legislation? Basically, anti-money laundering legislation obliges entities to report suspicious transactions to those FIUs, financial intelligence units. So we have entities like credit institutions, financial institutions, notaries, providers of gambling services, etc. They all have to report suspicious transactions to the FIUs. FIUs, financial intelligence units, are the central reception point for receiving those financial disclosures from obliged entities and providing national competent authorities with the results of their analysis. So they are organizations that actually look at those financial flows and analyze those financial flows, find suspicious patterns over there, and then when they find something suspicious, they have to inform the national competent authorities like prosecutors, for example, that there is something suspicious ongoing and that they might want to start a criminal investigation, criminal proceedings. So they are operationally independent entities in member states that receive, analyze, and they disseminate financial information, including personal data, to competent national authorities. Whenever those suspicious transactions are being detected by those obliged entities, they are reported to the FIUs either in the suspicious transaction reports, known as STRs, or suspicious activities reports, SARs. And when an FIU receives an STR or SCR, looks at it, finds something weird, and forwards it to the law enforcement authority. But the thing is that in the member states, we have three types of financial intelligence units. We have administrative financial intelligence units that are limited to receipt, analysis, and dissemination of those suspicious transactions and other reports. We have law enforcement financial intelligence units that are actually normally within a law enforcement agency or have a number of law enforcement powers given to them not by the anti-money laundering legislation of the EU, but by international law. And we have these hybrid FIUs that are basically something in between. And that's, you see, the problem, that we have very different setups at national level. Now the question is, why would you actually, what those FIUs should apply? Some member states say that their FIUs apply GDPR and it's okay for them. Some FIUs say that no, we are a law enforcement authority, we are a competent authority under the directive, we should apply the law enforcement directive. So there is a lot of discussion about this and a lot of arguments, and it's not clear what is the applicable law for the activities of the FIUs under the EU anti-money laundering legislation. The only thing I think this can be clarified is if the European Commission would initialize infringement proceedings against all the member states that decided that the lead applies to the FIUs and not the GDPR. And then we might also get a clarity from the Court of Justice of the European Union of what is actually a criminal offense under the directive and what is a competent authority under the directive. I think it's very important to enforce EU law also through those infringement proceedings by the European Commission. Otherwise, we will have to wait for interpretation by the court through some preliminary ruling that might happen in 10 years. And that is too long of a wait, and the situation is too unclear not to ask clarification from the Court of Justice of the European Union. And you can make arguments both ways, whether FIU should apply the GDPR or the Law Enforcement Directive. Those infringements potentially by the Commission would mean that the Commission shares my view, and that I don't know whether it does or not, that the FIU should apply the GDPR. Why am I saying this? Because FIUs have obtained specific tasks under the anti-money laundering legislation of the EU, which clearly separates financial intelligence units from the law enforcement authorities. So why would there be a distinction between those two if they are already competent authorities and should apply Law Enforcement Directive like all the other real law enforcement authorities? That is something that someone would have to explain to me, like I'm a 4-year-old, because that I don't understand. Another thing is that also the new directive, which is adopted under the police and judicial cooperation legal base, makes a distinction between FIUs and the law enforcement authorities. Then another example that I can give you, at the EU institutions level, we have OLAF, which is clearly an administrative authority, but it also looks at some sort of financial fraud, and when it detects the elements of financial fraud, what can it do? It can only forward its findings, its analysis, and its case to a competent law enforcement authority, which is currently at the national level, and in the future it might be the European Public Prosecutor's Office. So also at the EU level, we have this clear difference between OLAF as an administrative authority and EPPO as a law enforcement authority. Then you might compare the FIUs with the passenger information units. The passenger information units they have a different task, and if you look at the PNR directive, which regulates passenger information unit, it's clear that these are law enforcement authorities, or they are set up within law enforcement authorities with the task of preventing criminal offenses. So it's not comparable, at least in my opinion, and there is a big difference between the FIUs and the PIUs. So these are the arguments for applicability of the GDPR that I would like to put forward. And on the other hand, you have a number of people who, of course, say that no, FIUs should apply the LED, basically saying that there is a shift of gravity in the anti-money laundering legislation from internal market legislation to police and judicial cooperation legislation, that a number of financial intelligence units have a number of additional tasks that were given to them not by the EU law, or at least not by the EU AML law, but some other national or EU law that correspond to tasks of law enforcement authorities, that those FIUs have to apply Law Enforcement Directive because they are actually a law enforcement authority in the meaning of the personal scope that we discussed previously, and that it's impossible for them to juggle between Law Enforcement Directive and the GDPR depending on what they do, and then that FIU cooperation is essential for preventing more direct access to financial data by the law enforcement authorities, and they could exchange data and cooperate better, more flexibly when applying the Law Enforcement Directive. So I will finish my presentation here. Thank you very much for your attention, and I look forward to any questions that you might have, including from Ms. Kaushek, if I wasn't clear already during the presentation.